ACC Corporate and Business Law, Chapter 1 to 10 we have covered so far. So let's move towards Chapter 11, and the name of Chapter 11 is Insolvency. Insolvency means when company is unable to pay its debt. When company is unable to pay its debt, this means company becoming insolvent. So what's the process of insolvency? I mean, how company will be finished in case of insolvency or will be managed in case of insolvency. So we are going to study at the time of insolvency, what is the process of managing a company. So at the time of insolvency, there are two options. Either to liquidate the company, mean stopping operation of the company. In company operation will be ending. Company will be finished. Or there is administration. Administration mean to bring the company into better position. Means some steps, performing some step, taking some steps to bring the company to normal position or better position. So at the time of insolvency, mean when company is unable to pay its debt. So there are two options, either liquidation, mean stopping company operations, finishing company, or administration, mean taking some steps to improve company profitability, improve company poor position. Liquidation is of two types, voluntary liquidation or compulsory liquidation. Voluntary liquidation or compulsory liquidation. Voluntary mean where members have decided, okay, now we need to end this company. This is voluntary. Compulsory, due to certain reasons, it is necessary to stop the company. In company is demelting the society. So it is better to finish the company. Court had ordered to finish the company. That is compulsory. So the more detail in this chapter, we will study about liquidation. At the end, there are 2 pages about administration. So let's discuss about liquidation. So if a company finds itself in financial difficulties, the two main options are available. Administration mean the aim to rescue the company, improve the company, recover the company so that it may continue trading as a going concern. Or liquidation mean the wind up of the company, thus bringing its life to an end. Liquidation. There are two types of liquidation, voluntary and compulsory. What is voluntary liquidation? Voluntary liquidation occur when the members, shareholder pass a resolution to go into liquidation. And they have passed a resolution to end the company. The type of resolution need depend upon the circumstances. When the fixed period for the duration of the company expired, mean they started company for 5 years. So at the end of 5 years, they will pass a resolution to end the company operations. Because company was started for a fixed time period, fixed number of years. Or an event occurs upon which the articles provide that a company should be wound up, or if there is any condition, any statement written in the articles, like in these conditions, in these cases, we will wind up the company. Like if company profit fall below this amount, we will wind up the company. If company gearing ratio increases to this percentage, we will wind up the company. So there are two types of voluntary liquidation. One, when company is formed for a fixed time period and that fixed time period expires. And the other, there is a statement written in the articles, and according to that condition met, company need to wind up the company. So ordinary resolution is required in this case. In case the fixed time duration is completed or any of the condition as per article is fulfilled. So in that case, you are going to wind up the company, so ordinary resolution is required. A special resolution must be passed if the company is being wound up for any other reason, I mean, except these two reasons. If there is any other reason to wind up the company, then special resolution is required. Ordinary resolution means shareholder consent voting above 50%, 50% or more. Special resolution, shareholder consent voting 75% or more. There are two types of voluntary liquidation. Voluntary liquidation is of two types. One is by member, the other is a creditor. Members voluntary liquidation and creditors voluntary liquidation. It doesn't mean member voluntary liquidation mean members want to wind up the company and creditors voluntary liquidation mean creditors want to wind up the company. No. In both cases, member will pass the resolution. But what's the difference between these two? We're going to discuss. So member means shareholder voluntary liquidation is used when the company is solvent, mean able to pay its debts. Mean when company is able to pay its debt, but as the fixed time duration has been completed, or any of the condition written in article has fulfilled to wind up the company, mean company is solvent, mean company can pay its debt. But shareholder member want to wind up the company as the time period is expired, or any of the condition as per article has been fulfilled to wind up the company. When there will be creditor voluntary liquidation, when company is insolvent means unable to pay its debt. Mean company don't have funds to pay debts. Company don't have funds to pay money to the creditors from whom you bought goods on credit. Company is unable to pay loan, interest or installment. So that is insolvent. In that case, creditor voluntary liquidation will be processed. But if company is a solvent and shareholder have decided, okay, we should stop this company, so that is called member voluntary liquidation. So what's the process for both these liquidation? First, discuss about members voluntary winding up. In that case, winding up of company from a passing of an appropriate resolution mean members will pass a resolution first to wind up the company. Ordinary resolution. The directors make a declaration of solvency statement, mean they will proceed. Mean member will pass the resolution and who will proceed the winding up? Directors. So director make a declaration solvency statement stating that they are of the opinion that the company will be able to pay its debt within 12 months. Mean company is a solvent. It is a criminal offense to make a false declaration, but that declaration should be true, not false. So first, member need to pass a resolution. Then director need to issue declaration of solvency statement. The member appoint a named insolvency practitioner or liquidator, mean members will appoint a person as a liquidator. The person who help the company in winding up process. The person who help the company in winding up process. What is his role? Liquidator is having three roles. He need to sell company asset. He need to distribute money. Among creditors as well as a shareholder, and he will start the liquidation process. Liquidator is a person who will help the company in liquidation process. He will sell a company asset. Liquidation process mean he will value asset. Liquidation process mean value assets. We can sell this asset at this amount, then he will sell those assets, and the money received he will distribute first to the creditors, and then remaining to the preference shareholders, and then ordinary shareholders. The liquidator is responsible for realizing the asset, valuing the asset, and distributing the proceeds. The liquidator presents their report to a final meeting of the member, then he will present his liquidation report at the final meeting of the member. This is the value of the asset. We can sell at this amount, and this will be the amount that we can distribute among people. The liquidator inform the registrar of the company, and he need to inform the registrar of the company the final meeting and submit a copy of their report. He need to submit the report not only to members in the final meeting, to registrar, and the registrar registers the report, and the company is dissolved within 3 months. The registrar will dissolve the company, will wind up the company within 3 months. So what's the process of members voluntary liquidation? First, member need to pass a resolution. Director need to issue declaration of solvency statement. And then members will appoint liquidator. Liquidator will sell asset and distribute the money. And he will issue liquidation report to the member at the final meeting, as well as he will inform through that report to the registrar, and registrar will dissolve the company within 3 months. The same process company need to follow in case of a character voluntary liquidation. But what's the difference? Here, not only you need to inform members, you need to inform the creditors as well. He need to issue that report of valuing assets, selling, and distribution to the creditors as well. So creditors voluntary liquidation winding up. Winding up commence from the passing of an appropriate resolution. First resolution will be passed. Member appoint a liquidator. The director must then declare a notice to the creditors seeking their decisions on the liquidator. The director must also send to the creditor a statement of affairs within 7 working days. Instead of issuing declaration of solvency statement, here directors will issue a statement of affair within 7 days to the creditors. Directors will inform the creditors as well. The creditors can approve the liquidator, who will appoint liquidator? Shareholder. And that liquidator approval from creditor is also necessary. But any of the creditor with the 10% amount, they can reject that approval of liquidator. Because if they see might be this liquidator is working in best interest of shareholder rather than he is fair with the creditors, might be he will not value asset properly, or he will not distribute properly. So they can disapprove that liquidator appointment. So the creditors can approve the liquidator either by virtual meeting or by the deemed consent process. Under this process, approval is deemed unless 10% of the creditor of the company raise objection to the proposed liquidator. The members and creditors may appoint up to 5 persons to serve on a liquidation committee. They need to form a liquidation committee, and there should be 5 persons. This means liquidator approval from creditor is necessary, and 90% or above value creditors can approve, because 10% can disapprove. Like suppose company creditors is having a value of say 200,000. This is company creditor liability in the financial statement. 90% mean the creditors who are having value of 180,000 or more, they will approve the liquidation appointment. If creditors with 179,000 value have approved, the 11% haven't approved, so this liquidator will not be appointed. They need to seek for another liquidator. Mean creditor with 10% mean 20,000 or more value can disapprove the liquidator appointment. So how much creditor approval is required for liquidator appointment? 90% of. The liquidators submit their final report to the member as well as creditors. The liquidators submit a copy to the registrar and registrar will dissolve the company within 3 weeks. So in case of members voluntary winding up, first members need to pass a resolution. Actors need to issue declaration of solvency statement. Members will appoint a liquidator. Liquidator will sell asset and distribute money. And the liquidator need to submit report at final meetings of member as well as submit report to registrar, and registrar will wind up within 3 weeks. In case of creditors voluntary winding up, members need to pass a resolution. Then members will appoint a liquidator, and directors need to issue a statement of affairs within 7 days to the creditors as well. And the creditors will approve the appointment of liquidator having 90% or more value. Mean creditors with 10% or more value can disapprove the liquidator. And the liquidation committee must be having up to 7 members. Then liquidator will issue final report to the members as well as the creditors. Will submit the report to registrar, and registrar will dissolve the company within 3 weeks. Converting members voluntary liquidation into a creditors voluntary liquidation. Mean when members liquidation will be converted into creditors liquidation. What is the difference between member and creditors liquidation? Members voluntary liquidation is when company is a solvent, and creditors when company is insolvent. So when this member can be converted into creditors, if the liquidator discover that the company's debt will not be paid in full within the time specified in the declaration of solvency, mean they started proceeding for members voluntary liquidation by realizing company is solvent. But while valuing a company assets, liquidator find that no, companies are unable to pay its debt fully with the sale of asset, then this liquidation will be converted into creditors voluntary liquidation. So they must convert the members voluntary liquidation into a creditors voluntary liquidation. This is executed by following the process of creditors voluntary liquidation. Mean now they need to follow what? Creditors voluntary liquidation. Mean they started member voluntary liquidation. They appointed the liquidator. He valued the asset, and after valuing asset, he realized no, company debt are more, asset value is less. Mean company is insolvent. Then they will start proceeding of creditors voluntary liquidation. Mean members voluntary liquidation has been converted into creditors voluntary liquidation. Now the liquidator appointment should be approved by the members. They need to issue statement of affairs rather than declaration of solvency statement. Mean creditor voluntary liquidation process will start. They need to engage creditors now. They will approve appointment as well. So liquidation is of two types, voluntary and compulsory. Voluntary could be members, could be creditors. What is compulsory liquidation? Voluntary, when company fixed time period expire or any condition of article is fulfilled. Other than these two, whatever is the issue that will lead towards compulsory liquidation. So what is compulsory liquidation? A compulsory liquidation wind up commences when a petition for a winding up order is presented to the court. Mean due to these reasons, Court has ordered to wind up the company. The possible grounds for the petition are set out. The company has passed a special resolution to be wound up by the court. Mean through special resolution, member want to stop the company because might be company is not providing their benefit properly, and they have filed a petition in the court. This company is not protecting our rights, so it should be wind up. So court will order. A public company has not been issued with a trading certificate within a year of incorporation. There could be some issues relating to name of the company or some other issues relating to legal or illegal business. So after company incorporation, if trading certificate was not issued within a year, so ultimately company will not be continued. The court will order to wind up. The company has not commenced business within a year of being incorporated or suspended its business for over a year. Mean they haven't started their main business after 1 year of incorporation, or they suspended their business for 1 year. So court will order to finish this company. The company is unable to pay its debt. A company is deemed to unable to pay its debt where a creditor who is owed at least 750 pound has served a written demand for payment. The company has failed to pay the sum due within 3 weeks. If a creditor of at least 750 pound has asked the company for payment, but company is failed to pay him, so he will ask the court regarding the winding up, and the company failed to pay him within 3 weeks. So he can ask the court to proceed winding up, so that through winding up he can recover his money by selling the asset. A dissatisfied member may petition the court for the company to be wound up on the just and equitable ground. In one of the member was not satisfied with the company affairs, and if his allegation towards the company are equitable, based on equitable grounds, mean true, mean companies are not dealing them properly, companies not dealing members fairly properly, so court can order to dissolve the company. However, the court will not make an order under this ground in some other more reasonable remedy is available. Mean if whatever he is saying that is not based on equitable and just, then court will not pass the order to wind. Then might be court will ask the company or directors to keep him happy, whatever he want, try to give them or pay their money so that he can withdraw. Petitioner. Petitioner who is filing a petition to the court. The following person may petition the court for a compulsory liquidation: the company itself, the official receiver who is a civil servant, the insolvency service, and if an officer of the court to whom somebody have complained, mean member have complained or creditors have complained. The Department for Business, Energy and Industrial Strategy, under which companies are working, under which companies are registered, who define laws, rules for the company. So in UK, Department of Business, Energy and Industrial Strategy. I mean, this is government department who is monitoring the company's working. So might be they find like a company is not performing any act that is beneficial for the economy, and company have occupied so many area in the main part of the city, but this company is not beneficial for the economy, mean they are not providing any employment opportunities, they are not contributing towards national income of the company, so they can also ask the court to give order to wind up. The contributory, this is any person who is liable to contribute to the asset of the company when it is being wind up. mean creditors, shareholder who can receive money after selling of the company, he can ask the court. The contributory must prove that company is solvent. And a creditor who is owed at least 750 pound and company didn't pay him within 3 weeks of his request for payment. Effect of winding up. What will be the effect of winding up? The winding up petition has the following effect. The liquidator is deemed to have started when the petition was first presented. All action for the recovery of debt against the company are stopped because now liquidator will sell the asset and distribute money. Any floating charges crystallizes, mean floating charges will become a fixed. Crystallizing mean when floating charge mean charge on inventory, mean loan on inventory can be converted into fixed charge. Fixed charge mean like you cannot buy sell this inventory. We have discussed floating charge and fixed charge. Crystallizing mean conversion of floating charge to fixed charge. Mean inventory will be stopped moving. Any legal proceeding against the company are halted and none may start unless leave is granted from the court. Any legal proceeding mean any claims from the customer, from the employee, they will be also be halted. Company will not pay any money. The company ceases to carry on business except where it is necessary to complete the winding up, for example, to complete work in progress. Mean if there is any inventory in work in progress, so that you can complete to finish goods. Otherwise, that will be destroyed because while converting to finished good, at least you can sell and recover some money. Otherwise, all the business activities should be stopped. The power of the directors cease. Although the director remain in office, but they will not be able to make major decisions. The employees are automatically made redundant, but the liquidator can re-employ them to help him or her complete the winding up. If you need any employee like inventory in work in progress, you need to convert into finished goods, then you can use some employees. Otherwise, employees are automatically redundant. What with the subsequent procedures? On the meeting of the winding up order, the official receiver become liquidator. Our court will nominate this person is a liquidator. What is the role of liquidator? Valuing company assets, selling company asset, and distributing money. So within 3 months, the official receiver with the summon, mean order from the court, meeting of the distributor in order to appoint a licensed insolvency practitioner to take over the job of liquidator, and within 3 months, he will appoint any other specialist liquidator. Creditor's approval of the liquidator is sought via the deemed consent process. If 10% or more object, an alternate decision-making procedure should be virtual meeting should be used. In creditor, approval is also required. The liquidator is responsible for releasing the asset and distributing the proceeds. The liquidator returns to the court and the court pass an order dissolving the company. As well as the liquidator must file to the registrar the final report, and registrar will dissolve the company from the date of the order, not within 3 months from the date of the order. Allocation of asset mean how asset will be sold and distributed. The liquidator must repay debt in the following order. By selling asset of the company, first he will pay to the fixed charge holder, normally bank loan, who provide loan against fixed asset. Then expenses of liquidation, because during liquidation you need to incur some expenses. It might be you need to engage some of the expert who will value the asset. They will charge a fee. And then preferential creditors. Preferential creditors mean wages or salaries due in 4 months preceding the commencement of the winding up, maximum 800 per employees if previous wages salaries are pending. All accrued holidays pay.
That should be last.
Now, these are preferential creditors. Their current pay is not preferential, but previous pay, previous pending dues are preferential creditors. All preferential creditors rank equally among themselves. Means you should treat all the employees equally. Then secondary preferential creditors. Secondary preferential creditors mean if there is any money due for HMRC, mean tax authorities, tax payable. Then floating charge. So first fixed charge, then expense of liquidation. Preferential creditors mean wages, salaries, undue and expense payable, then floating charge holder, and then unsecured creditors mean creditors from whom company bought goods on sale, goods on credit, the creditors. Then post liquidation interest, if there is any interest company need to pay. Then shareholder declared but unpaid dividend. Then members return of capital, then their capital will be distributed first to preference and then to ordinary. Any surplus to be distributed among ordinary shareholders. If company is having more assets, less liabilities, the surplus money will be distributed among members. I mean, after paying their amount of investment, if there is any surplus, it will be distributed among members. So we have covered two processes at the time of insolvency liquidation. The other is what? Administration. I mean, taking some steps to improve company position, to secure the company. So administration involves the appointment of the insolvency practitioner known as an administrator. I mean, he will perform some steps. He will order something. He will see the issues, try to resolve it so that company should be put into better position to manage the affairs, business and property of the company. It was first introduced by Schedule 16 IA 1986, but has subsequently been amended by the Enterprise Act 2002. Administration is often used as an alternate to putting a company into liquidation. Instead of liquidation, you are trying to improve the company. For example, to rescue a company in financial difficulty with the aim of following it is continue as a going concern. Achieve a better results for the creditors than would be likely if the company were to be wound up. Means through this, you can pay even more money to the creditors. Realize a property to pay one or more secured or preferential creditors. Mean you can pay creditors a little bit more by taking some steps for improvement. The administrator can only use the third option where they think it is not reasonably practicable to rescue the company as a going concern. Mean these two, they cannot perform. So then they will take some steps. Mean company will be moving towards winding up, but they try to do something so that they can receive better value for asset. So when this third option, they will apply when they think it is not reasonable practicable to rescue the company as a going concern. They think that they cannot believe a better result for the creditor as a whole than would be likely if the company were to be wound up. They don't unnecessarily harm the interest of creditors of the company as a whole. They don't want to put the creditor into a position to lose all their money. So they will do something to recover a little bit more.
That's risky.
Who can appoint administrator? Administrator can be appointed by any of the following person. The court in response to petition by, for example, a creditor, the director of the company itself, mean when petition is filed by the creditor or director, then court can appoint the administrator. the holder of a qualifying floating charge over the company asset, mean the person who have provided debt against floating charge, he can appoint the administrator. The company or its director, provided that wind up has not already begun, mean company is running, but company or director themselves can appoint any administrator so that company can be rescued. So who can appoint? Court order,
Court order.
floating charge holder, or company or director if company haven't started winding up mean liquidation process.
Can they nominate themselves like?
Yeah. The court will only agree to appoint an administrator if it is satisfied that the company is or is likely to become unable to pay its debt, and the administration order is likely to achieve its objective, mean the administrator will be able to rescue the company. Then court will opt for administration. Consequences of administration. In what will happen? The appointment of administrator has the following effects. The right of creditors to enforce any security over the company's assets are suspended. There can be no enforcement of charges, retention of title clause, or hire purchase agreement against the company. Mean supplier will not be having strict claims against assets. Any outstanding petition for winding up is dismissed. If there is any court case going on, that will be dismissed. No resolution may be passed to wind up the company, and a shareholder will not be able to pass a resolution for liquidation. The directors still continue in office, but their powers are suspended. Who will be having power? Administrator. Carrying out the administration, the administrator has a number of tasks. They are the company's agent, mean working on behalf of company, but must act in the best interest of all the company's creditors. They can do anything necessary for management of the company. They have a wide power to manage the business and property of the company, including the power to bring and defend legal proceedings, sell asset, and borrow money. With regard to selling assets, this include property which is subject to both fixed and floating charge, which may be disposed of without the consent of charge holder, although they retain first call against any money released by the sale of asset. Mean first they will pay to the charge holder, but they can sell without consent of charge holder. In respect of assets subject to fixed charge, this will require the court permission, but they will not be able to sell asset on fixed charge. Floating charge, they can sell without consent of charge holder, but the money first will be paid to charge holder. For fixed charge, they cannot sell asset without having court permission.
The way they.
Mean he will take some steps if we need to sell some asset, so that company should be having some money so that the company can put into operations and recover their business. So he will do that. They have the power to remove and replace directors and employees if they were not working properly. If an employee's contract is not adopted by the administrator within 14 days, that employee is made redundant. They can pay out monies to secured or preferential creditors without the need to seek approval for the court. This can also pay out monies to unsecured creditors, but this must be with the approval of the court. To secured creditors, they can pay money without court approval, but to unsecured creditors, they need to take court approval first. The administrator has also a number of legal duties. As soon as is reasonably practical after appointment, they must send a notice of appointment to the company and publish notice as appointment. Publish on company website. They must obtain a list of company creditor and send a notice of appointment to all creditors as well. And within 7 days of appointment, they must send a notice of appointment to the registrar of company. Mean they need to send a notice to the company as well as publish. They need to send a notice to all creditors and they need to send notice of appointment to the registrar. They will arrange for certain relevant people to provide a statement of affairs of the company. Mean what are the issues, how we are resolving. They must ensure that every business document of the company bears their identity as administrator and a statement that a company affairs are property are being managed by them. Based on the statement of affairs, they must draw up a statement of their proposal with 8 weeks of his or her appointment. The proposal must be approved by the creditors of the company as well. And this approval can be given by deemed consent process, virtual meeting, or some other reasonable method. Mean creditor approval is required. The creditor have the right to form a creditor meeting of between 3 to 5 creditors. If formed, the administrator must hold a meeting of the creditor within 6 weeks of the establishment. If creditor want to hold a meeting with administrator, then he need to conduct that meeting within 6 months of their consent. If the creditors do not approve the proposal, the court may dismiss the administrator to make such provision as it sees fit. If the creditors approve the proposal, the administrator can carry them out. Ending the administration mean when administration will be finished, when he is appointed for work and that work is finished, administration will be removed. The administration will end when it is completed or when the administrator is discharged by the court. The administrator must normally be completed within 12 months of the date on which it is commenced. However, this term can be extended within the consent of the court or the secured creditors, but normally administrators are appointed for 12 months. The administrator may apply to the court for discharge at any time, mean before 12 months. They must make an application when the purpose of the order has been achieved. They must also notify the registrar and all of the creditors, like I am going to remove from the company because I have finished my work. So chapter finish. Mean at insolvency, there are two options, either liquidation or administration. Liquidation could be voluntary, could be compulsory. Voluntary, expiry of fixed time period, as well as condition fulfilled as per article. And voluntary is of two types, member voluntary liquidation and creditor voluntary liquidation. Members when company is solvent, creditors when company is insolvent. And the other process is administration. So let's take a break. After break, we will discuss about